Good evening, everybody. This is SK Ghosh. I would like to welcome you to the fourth offering in this series of general and structural seminars. We did the first two modules last Tuesday, the third one last Wednesday. Today is the fourth offering. Tomorrow will be concrete materials at the same time as today. Today's topic is Rajuk's Vidhimala, the 2008 edition mostly, although Dr. Rakib may talk about changes that we have recommended. The Building Construction Act of 1952 and the Town Improvement Act of 1953. How these documents interrelate with one another and how they regulate buildings or building construction in the Dhaka metropolitan area. We are very lucky to have Dr. Akib give us this segment today and also tomorrow's segment on construction materials. The question and answer session at the end is important. As last week, we will try to answer as many as we can during that session. There were many questions left over from last week. We still do not quite know how to handle them in view of the volume that we are getting, but we will come to some kind of a resolution, hopefully. Okay. With that, Dr. Akib, ladies and gentlemen.
Thank you, Dr. Ghosh. Good evening, everyone. Once again, we will have a session on building code, but today the topic is not directly related to building code. It's on Vidhimala, that is Building Construction Rule of Rajuk, and Building Construction Act and Town Improvement Act. All these are legal documents, but I'm not a legal expert. So please don't take today's session as a legal discussion. Today, since I had some experience with the building code, so I have some understanding how the building code relates to these legal documents. So I will discuss from that context how these legal documents are related with the building code. So let's start. Although the order in which they are mentioned, Vidhimala, BC Act, and TI Act, is according to the relevance of these legal documents with the building code. That is, Vidhimala is the most related document to the building code, and then BC Act and Town Improvement Act is not that much related, but of course, there are some relations. So we'll talk about that. But first, let's see what is the chronological order. Dr. Ghosh has already mentioned that the Building Construction Act came first. That was enacted in 1952. But later, this act was finally amended in 2006. During that time, the Bangladesh National Building Code was mentioned in this act. And the next year, in 1953, the Town Improvement Act was enacted. It was amended quite a number of times. And the most important amendment came in 1987 when RAJUK was established. Before that, it was DIT, Dhaka Improvement Trust. But through the amendment in 1987 of the Town Improvement Act, RAJUK came into being. And the last one, chronologically, Imarat Nirman Vidhimala, or Building Construction Rules, that was drafted and actually changed, quite drastically changed quite a number of times 1984, then 1996 was completely a new rule, a new set of rules, and in 2008 it was drastically changed. And the presently we follow Dhaka Imarat Nirman Vidhimala that was drafted in 2008 and gazetted in 2008. So I'll follow this chronological order because this order gives makes it easy for us to understand the context of one law, how it is related to the previous one. So I'll follow this order instead. So first we'll talk about the Building Construction Act 1952. The purpose of this act, as it is mentioned here, is an act to provide for the prevention of haphazard construction of buildings and excavation of tanks which are likely to interfere with the planning of certain areas in Bangladesh. So the main purpose was to prevent haphazard construction. I'm sure that you understand that this very purpose is quite relevant even today. All around us, we see haphazard construction. So this is very much relevant, this act, even today. And we can rather question how the act actually helped us to prevent the haphazard construction. So it's all up to you. We'll not go into that discussion, but that is the purpose. Second, what is the extent of this act? That is, where it is applicable. It is applicable over the whole of Bangladesh, in the entire country. So this is important. All acts are not applicable over the entire country, but this one is. Now, there are many definitions mentioned in the Act. I will mention a few which will be useful for us to understand the other documents. First one is authorized officer. By authorized officer, it is meant that an officer appointed by the government by notification in the official gazette to exercise in any area of the functions of an authorized officer under this act. So this is important. We have to understand. Authorized officer will be appointed by the government. So it doesn't say that authorized officer belongs to any particular organization like RAJUK, CDA, KDRDA. An authorized officer can belong to any organization. All that is needed is his appointment through gazette notification. That's very important, that an authorized officer can belong to any organization, government organization. Secondly, the functions. What are the functions? The functions are described in this act and in other legal documents like the Vidhimala and the building code. Because those are mentioned in this act, and the functions that are mentioned in those rules and code and the code will also be valid under this act. So the functions we can understand. What are the functions of the authorized officer? We have to go through this act, the Vidhimala, and the code. Now, the definition of building. It is really interesting that the building is defined as something which includes a house, outhouse, hut, wall, and any other structure, whether of masonry, bricks, corrugated iron sheets, metal, tiles, wood, bamboos, mud, leaves, grass, thatch, or any other material whatsoever. Luckily, the last phrase was mentioned, that any other material whatsoever, otherwise concrete would have been excluded. So this is a very archaic, outdated definition of building. Our code, Bangladesh National Building Code, has more relevant definition of a building. So these are something that since the act was enacted in 1952, long time back, some of the definitions and provisions are quite outdated, that you'll understand. And there is another definition of temporary building, means such building which is declared by the authorized officer to be of a temporary nature. That is, it is up to the judgment of the authorized officer to declare something temporary. So these are few definitions. There are many definitions, but I thought these would be useful. Next, sorry, restriction on construction of building and excavation of tank. Oh, one more interesting thing. Everywhere where uh, it is written construction of building, it is paired by another phrase, excavation of tank. Most probably during the time of 50s, uh, excavation of pond or tank was very common in Dhaka. Now this is just the opposite. We never see any excavation of tank, or rather we always see filling up of all ponds and tanks for further construction. So these are the things that are quite interesting. But in this act, excavation of tank is mentioned everywhere. Whatever, I'll start with subsection number 3.1. Let's see, actually by restriction here, it means taking permission, availing permit. Let's read it out. Notwithstanding anything contained in any other law for the time being in force or in any agreement, no person, uh, there's something here so that I cannot see. No person without the previous sanction of an authorized officer construct or reconstruct or make addition or alteration to any building or excavate or re-excavate any tank within the area to which this act applies, and such sanction shall be subject to such terms and conditions as the authorized officer may think fit to impose. So basically what it's saying that if you want to construct a building, you have to take permission. You have to avail a permit for that. And who will provide you that permit? The authorized officer. Here, just notice that instead of the term permit, the term that is used to mean the same thing is sanction. So in legal term, it is sanction, but in the Vidhimala and in the code, you'll see it is mentioned as permit. These are all same thing. So we need permit to construct a building. Subsection 3.2, the government may, by notification in the official gazette, direct that the power of an authorized officer under subsection 1, that is what I just read out, shall be exercised by a committee in such area as may be specified in the notification. So instead of resting the power with the authorized officer, the government may give the power to a committee, usually what we know as BC committee, Building Construction Committee. So it is mentioned in the Act that the government may give the power of the authorized officer to a committee, but it has to be by gazette notification. 3.3. When a notification under subsection 2 has been issued, the authorized officer shall not exercise the power conferred on him by subsection 1 in the area to which the said notification relates. That is, once there is notification that there is a BC committee, once a BC committee is formed, the authorized officer must act through the BC committee. The authorized officer cannot exercise the power mentioned in this act. The power will be exercised by the committee, and authorized officer will see later in the notification the position of the authorized officer is member secretary in the committee. So this is important. Then we can understand what is the role of the authorized officer and what is the role of the committee. Now, as it is mentioned that there are restrictions on construction of building, that is, you need permit to construct a building. Now, to use a building, you need permission. That is, so that you cannot use a building improperly. So this is restriction on improper use of lands, not only building, lands and buildings. So this is 3A. The subsection 3A1 says no owner or occupier, not only the owner or occupier of a building shall, without obtaining previous permission from the authorized officer or the committee, as the case may be, use the building for the purpose other than that mentioned in the sanction. So in the building permit, there will be mentioned what should be the use of this building. If you use for any other purpose, for example, in the permit it is written residential. If you use it commercially, you cannot do that. You need to take permission for that. You need to have permit. 3A2 says, when the authorized officer is satisfied that the existing use of any land or building does not conform the scheme of land utilization indicated in the master plan, the authorized officer may, by an order in writing, direct the owner, occupier, or the person in charge of the land or building to discontinue such use, and in the case of a building, also to remove or dismantle such building. So this is an enormous power. So if the authorized officer finds that the building is not used in the prescribed manner, that is what is written in the permit, then he can direct the owner or the occupier that you must stop using this building. Or even the authorized officer can ask the owner to dismantle or remove the building. But there is one exception. Provided further that no existing or further use of any land or building for combined residential or commercial purpose shall be discontinued or prohibited. So in case of commercial and residential purposes, there is exception. The authorized officer cannot just discontinue the use of it or prohibit the use of that building unless there are some conditions. In any particular case, such use militates against the dominant character of the scheme of land utilization as indicated in the master plan. So, suppose in the master plan the land is shown as residential, as um, uh, residential, and you are using it commercially or for some other purpose. If it is contradictory to the master plan, in our case DAP, detailed area plan, and not all, and constitutes a nuisance generally to the zone and particularly to the neighborhood in which the land or building is situated. So just only because it is mentioned that this is a residential plot and you are using it commercially, authorized officer cannot ask you to discontinue or stop using the building. He has to also show if it is the case that the use is such that that causes nuisance in the neighborhood. Only in that case, for residential and commercial building, the authorized officer can direct to discontinue the use of the building. So this is interesting. So we see here that the authorized officer has the power to ask the owner to stop using the building or even to remove or dismantle the building in certain cases. So if how that will be, that power can be exercised. So the modus operandi is mentioned here. There is 3B. When it appears to the authorized officer of the committee, as the case may be, that any building is being constructed or reconstructed, or any addition, alteration to any building is being made, or any tank is being excavated or excavated without obtaining the sanction. So if you don't have the permit, but still you are trying to construct a building, or you have constructed a building, in that case, what happens? Under section 3, or in breach of any other terms or conditions subject to which sanction was granted under the section. So you are doing something in contradiction with the permit that you have. He or it, he is the authorized officer, it is the committee. Either the authorized officer where there is no committee, or the committee may, by a notice, direct the owner, the occupier, and the person in charge of the building or the tank to show cause within such period, not being less than 7 days, as may be mentioned in the notice. Why? So he, the authorized officer or the committee, can issue a notice. The notice will ask the owner to show the cause for what, why the building or any portion thereof, whether constructed or under construction as may be specified in the notice, should not be removed or dismantled, or further construction or reconstruction or addition or alteration to the building or excavation of the tank should not be stopped. He can ask for two things. The authorized officer or the committee can ask for two things. One, they can ask the owner to stop the construction or remove the building or dismantle the building or part of it. And before doing that, this notice must be served that why that will not be done. So this is very important. So if an authorized officer or the BC committee wants to exercise this power, this notice must be served first, and there will be a time given to the owner or occupier um, by which he or she has to respond, and that time must be something longer than 7 days. So after the notice is served, then what should be the procedure? When a person is asked by a notice under subsection 1, the previous subsection, to show cause why further construction or reconstruction or addition to or alteration to any building or excavation of any tank should not be stopped. He shall stop such further construction or reconstruction or addition or alteration or excavation as the case may be from the date the notice is served on him till an order is made under subsection 3. So as soon as the notice is served, the owner must stop construction of that building. The owner cannot continue construction unless uh, he shows the cause and the cause is satisfactory and the case is vacated. Unless that is being done, with the serving of the notice, issuance of the notice, the construction work must stop. And then, where after considering the cause shown, if any, within the time mentioned in the notice, and giving the person showing the cause a reasonable opportunity of being heard, or where no cause is shown within such time, the authorized officer of the committee, as the case may be, after such inquiry as he or it deems fit, is satisfied that the building has been or is being constructed or reconstructed or addition or alteration to the building has been or is being made, or the tank has been or is being excavated or excavated without obtaining the sanction. So if it is the case that even after the notice is served, the owner may give reply to that notice. If that reply is not satisfactory, and the authorized officer of the committee is, if the authorized officer of the committee is convinced that actually there is no permit, the owner doesn't have the permit, then under section 3, or in breach of any of the terms, but or the owner may have permit, but he or she has violated some of the terms in that case, and conditions, terms and conditions, subject to which sanction was granted under that section. In that case, if the owner doesn't have the permit, or the owner has violated some of the clauses of the permit, in that case, the authorized officer or the committee may, by an order in writing, stating reasons therefore, direct the owner, the occupier, and the person in charge of the building or the tank to remove or dismantle the building or any portion thereof, or to fill up the tank or any portion thereof as specified in the order, uh, within such time as may be fixed by him, or to stop further construction or reconstruction, addition or alteration, or excavation as the case may be. So, in that case, there can be a final order. After issuance of the show cause notice, after the owner replies to that notice, if that is not satisfactory, then finally the committee or the authorized officer can dictate that the building must be removed, or the construction must be stopped. If the reply is satisfactory, in that case, otherwise shall make an order vacating the notice. So if the reply is satisfactory and the authorized officer and the committee, they're convinced that, okay, uh, the owner has the permit and he has not violated any clause, in that case, the initial notice that was given to the owner will be vacated. That is, there will be no case against him. So that is the procedure for removal of a building or stopping any construction work. Now, suppose the final dictation has been issued by the authorized officer of the committee that the building must be removed. But if the owner doesn't comply with that, then what will happen? So that is written in subsection 7.1. If any person fails to comply with any direction for removal or dismantling of any building or any portion thereof, or filling up any tank or any portion thereof, given to him under section 3b, within the period there fixed, therefore, the authorized officer or the committee, as the case may be, may cause the building or portion thereof to be removed. So even if the owner doesn't comply with the direction, then the committee or the authorized officer, they themselves can mobilize forces to remove the building or the tank or portion to be filled up, as the case may be, by using or causing to be used such force as may be deemed necessary. So they can use force for this purpose. And the cost thus incurred shall be realized from its owner in the manner laid down for recovery of fine under section 386 of the Code of Criminal Procedure 1898. So this is the procedure that if the authorized officer of the committee thinks that some illegal construction is going on, then they have to first issue a show cause notice. If the reply is not satisfactory, then they will dictate, give another notice, final notice, that this building has to be removed or the construction has to be stopped. If the owner doesn't comply with that notice, then the authorized officer or the committee themselves can mobilize force to remove the building or stop the construction. In that case, if any cost is incurred, that will be finally borne by the owner. That will be realized from the owner in some legal manner. So that is the whole story for removal of a building. Now, first of all, so far it was written that you need a permit for construction of a building. If you don't take a permit and try to construct what are the consequences, that was mentioned first. Now it is written how to get a permit. So you have to apply to get a permit. An application for sanctions mean actually permit. An application for sanction under Section 3 or Section 3C shall be made to the authorized officer of the committee, as the case may be, in such manner and form, and on payment of such fee as may be prescribed. So you have to apply for a permit, but there will be a prescribed form, and certain prescribed amount have to be paid. Now, who will prescribe it? Where will the prescription come from? This is written later in another subsection. Actually, these things, the forms, the fees, the amount of fees, these will be mentioned in the building construction rules, that is Vidhimala. So this is the relation. Vidhimala is kind of a bylaw for this law. So these prescriptions will come from the rules, Vidhimala. Then subsection 9, the sanction granted under section 3 or section 3C shall be liable to cancellation by the authorized officer of the committee, as the case may be, for breach of any of the terms or conditions, or making statements not correct under which such sanction was granted. So the authorized officer and the committee, they have the power to revoke the permit. They can cancel it. Entry into premises. This is interesting. Now, so how can an authorized officer will understand if we were constructing illegally? What is the way? The authorized officer or his representative must see that. That is, they must get into your premises, enter into your premises and see that the construction is going on and that is not according to the permit, or you don't have the permit, things like that. So for that, the authorized officer needs a legal support that he or she, the authorized officer, can enter into a premises. Normally, under the law of the country, no one, even a police officer, cannot enter into your property. If a police officer wants to enter your property, he must have a warrant for that, warrant from court. If not, then he cannot enter. This is the privacy, because of the privacy. But here, this is different. This is a very, the authorized officer enjoys a big power here, a privilege. 10.1 says, for carrying out the purposes of this act, an authorized officer or the committee or any person empowered by him or it in this behalf may, after given reasonable notice to the occupier of any premises, enter upon such premises after sunrise and before sunset. So an authorized officer cannot enter a property, premises after sunset, but he can enter between sunrise and sunset, provided that he issues a prior notice to the owner. Once he issues a notice, he has every right to enter your building or your property. Second, 10.2 subsection, the owner of any building or tank or hill shall, on being required by an authorized officer or the committee or any person empowered by him or it in this behalf, produce before him or it the sanction obtained therefore under section 3 or section 3C. So the owner has to show the permit to the authorized officer or his representative or the committee's representative. And in the building code, it is written that the building permit must be preserved at the site, so that upon request by the authorized officer, in that case, building official, the same thing. In the language of the code, it is building official. In the language of the act, it is authorized officer, the same person. So when the building official or the authorized officer or the committee or their representative asks the owner for the permit, it is compulsory for the owner to show the permit to that person. Now, penalty. So, the one power that authorized officer or the committee enjoys is that they can direct for stopping a construction or removal of a building, and at the same time, this is a punishable offense. Violation of any of the provisions of this act is a punishable offense. Let's see what it says. Subclause 12 is regarding penalty. 12.1 says, whoever commits an offense by A, so what are the offenses? A, contravening the provision of section 3, that is, you must have a permit. If you don't have a permit, you cannot construct. If you contradict that, that is, you start construction without having permit, then you are punishable. B, failing to comply with any direction given to him by an authorized officer or a committee under section 3B, or by an authorized officer under section 4 or subsection 1 or section 5, or that is, whatever the direction of the authorized officer or the committee is, you have to comply with that. If you don't do that, you are committing a punishable offense. C, designing or approving or implementing a building construction plan in contravention to any provision of the Bangladesh Building Code made under subsection 18A and the rules made under section 18. This is interesting, very, very. Here it is the first time that building code is mentioned in this act, in the penalty section clause, that whoever, if he designs or approves or implements in anything in contradiction to Bangladesh Building Code. So whatever written is there in the building code, if you go against that by designing or approving or implementing, you are committing a punishable offense. Now, this is very important. First of all, who 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 will be punishable? Who is committing these offenses? So, if you don't have a permit, still you construct, who will be punishable? The owner, right? So the owner can be punishable. Secondly, if you use a building not according uh, to what is written in the permit, so who will be punishable? The occupier. The owner may be punishable, the occupier may be punishable. And here it is written designing. Who will design a building? Violating building code clauses? The designer. So the professional may also be punishable. Or approving. Who will approve a building construction? The authorized officer or the approving authority, building official. The authorized officer or building official, they themselves may be punishable. That is, if approves, or someone can illegally approve. That in certain locality, it is the jurisdiction of the authorized officer of the committee. There, some other person, if influences and approves the construction, he may be punishable. Or implementing, who will implement? That is the contractor who is constructing the building. If the contractor doesn't follow the building code provisions, he will be punishable. So all these people, the owner, the occupier, the designer, someone approving the construction, and the contractor or the developer. Not only the building code, it is also written, and the rules made under section 18, that is the building construction rules, that is Bidhimala. If anyone does anything against the rules of the Bidhimala, he or she is punishable. D, constructing a building in contravention to any provision of the building Bangladesh Building Code main under Section 18A. So again, the construction, it is related to construction, and the implementation is that planning probably. I don't know. I thought that these two are same. Maybe there is some difference. I don't know. Shall, on conviction before a court of competent jurisdiction, be punishable with, so there will be a case in a legal court, and if the court finds the owner or the occupier or the designer guilty, the court can punish. So what would be the punishment? Be punishable with imprisonment for a term which may extend to 7 years. That is the maximum term. Can be jail term, 7 years, or with fine not less than taka 50,000. Or so if anyone violates the building code or the rules or this act, may go to jail or may not. He can pay of some fine, but the fine amount of fine will not be less than 50,000, or with both, or may be punished by jail term and fine. And the court convicting the accused shall, if an application in writing is made by the prosecution in this behalf, fix a date within which the building or tank or portion thereof in respect of which the offence has been committed shall be removed or dismantled or filled up, as the case may be, by the person convicted, and may, for sufficient reason extend such date. So what the court can also do is that if the person who is found guilty, if that person applies or pleads or wants a petition from the court that is that they an extension of time by which he will comply with the dictation of the authorized officer of the committee, the court can extend that time without giving punishment. So this is the penalty. So from this clause we understand who may be punishable, for what reason, and what could be the punishments. So this is important. Now, cognizance of offense. So this is very important. 13.1, very strong statement. An offense punishable under subsection 1A, just the previous section of section 12, shall be cognizable and non-bailable. So very, very harsh words. Cognizable means the police can arrest the convicted person or for alleged conviction uh, without any warrant. So a police can arrest if the authorized person officer finds that this person is guilty. The police can arrest without warrant and start an investigation without the permission of the court. Cognizable means the police can arrest the person without warrant and start an investigation without requiring for a permission from the court. And non-bailable, and he cannot uh, apply for bail even. So he has to be in the jail, or he has to be in the custody, police custody. 13.2, subject to subsection 1, no court shall take cognizance of any offence punishable under this act except upon a complaint by the authorized officer or the committee, or by a person authorized by the authorized officer or the committee, as the case may be. So these cases can only be um, lodged by the authorized person or the committee. No other person can do that. So once that is done, so police can arrest the person without warrant and start investigation. So these are very, very harsh legal provisions. Okay, then bar to jurisdiction of civil court and appeal. So these are two different clauses. One is bar to jurisdiction of civil court and another is appeal, but they're related. 14 says every order under section 3 or section 3A or section 3B or section 3C or section 3D regarding permits, or section 4 or section 5 or section 6 or section 9. So these are related to the dictation of the authorized officer of the committee, shall, subject to the provision of section 15, that is appeal, be final and shall not be called in question in any civil court. So you cannot go to the court saying that the authorized officer has done some injustice to me. You cannot do that. You can appeal, but that's a different procedure. But you cannot go to any civil court. So these are very, very sweeping power for the authorized officer. It is not questionable to any civil court. So what you can do at best is appeal. So that is section 15. An appeal, if presented within 30 days from the date of the order appealed against, shall lie to such officer or authority as may be prescribed, again the term prescribed, against every order under section or section 3A or section 3B, section 3C, 3D, 4, 5, 6, 9, and the decision of such officer or authority on such appeal shall be final and shall not be called in question in any civil court. Again, so what best you can do if the authorized officer gives dictates something or gives some verdict, you can appeal against that. To whom? That will be prescribed. Who will who will judge your appeal? That will be prescribed. Prescribed means that is written in the rules, Vidhimala, the bylaws. So in the Vidhimala, who will uh, who will judge your appeal is written there in the Vidhimala. So that is the best you can do if you are if you have committed anything against the building code or law, BC Act or the Vidhimala. And if the authorized officer dictates to something, you can go for an appeal, and there will be some authority who will judge your appeal. But that's the best. You cannot go to any civil court. Now, indemnity. No suit or legal proceeding shall lie against the government in respect of anything which is in good faith done or intended to be done under this act. Against the government means actually the authorized officer and the committee. So you cannot lodge any case, any legal suit against the government for the actions or activities done under this act. The second one is more general, just saying no suit, prosecution, or legal proceeding shall lie against any person in respect of anything which is in good faith done or intended to be done under this act. So here, if the person doesn't belong to the government, but for the purpose of uh, applying this act, if any person acts, does something, so you cannot go to the court and file any case against him if that person acts in good faith for the purpose of this act. So who that person can be, uh, the only thing I can think of is third party. So who any person who acts on behalf of the authorized officer of the committee or the approval authority or the government as such. So that's another sweeping power for the authorized officer of the committee. So it's complete, enjoys complete indemnity. Power to make rules. This is important. So far we have learned about the first thing the act says that you need permit. If you don't have the permit or go against the permit, so these are the consequences. They're punishments. and the authorized and the officer and the committee, they enjoy sweeping powers. So far we have understood that, but there are some provisions where it is written that it will be prescribed, like uh, who the appellate body, that will be prescribed, and the fee for permit, the form for permit, those will be prescribed. Those prescriptions, where from we will get those prescriptions? From the rules. It is mentioned here. Power to make rules, section 18. So 18.1 says the government may make rules for carrying out the purposes of this act. So the government may make rules. Okay. Second, in particular and without prejudice to the generality of the foregoing power, such rules may provide for all or any of the matters. So what will be there in the rules? Following things, from A to H. These will be there in the rules. Number one, the constitution of a building construction committee. Here, from the very beginning, from subsection 3b, it is written that the government may form a committee who will act for the authorized officer. So in these rules, the building construction committee may be constituted. B, the tenure of, and from B to E, these are all related to this committee. Tenure of the officers, resignation, removal, vacancy, etc., etc. Code of conduct of business, etc., etc. Meetings. These are all related to simply BC committee. So the government can uh, constitute BC committee by the rules. Number one. Then the manner of service of notice under sections. So all the notices, the forms of notices, what will be the forms of these notices, how they will be served. So that will be there in the rules. And then the form of application for sanction. It is written previously in the act that there will be prescribed form using which you can apply for the permit of the sanction. So in the rules, that prescription will be in the rules. The exact form will be in the rules. That is Bidhimala. The amount of fee payable under section 8. That is, for all these, you have to, the fee structure will be in the rules. That is the Bidhimala. So in the Bidhimala, only these things are supposed to be there. BC committee, notices, forms, fee. Actually, the act gives this much power to make rules. So this is important. Please remember this, because I'll talk about this again later when I'll talk about Bidhimala. And the next clause, this was the amendment in 2006, power to make Bangladesh National Building Code, subsection 18A. 1. The government may, by notification in the official gazette, make provision to carry out the purposes of this act, and the provisions made under this section may collectively be called the Bangladesh National Building Code. So the provisions mentioned here, when those provisions will be in a document, and if that document is gazetted, that document will be called Bangladesh National Building Code. So what will be there? Without prejudice to the generality of the foregoing power, the Bangladesh National Building Code may provide for all or any of the following matters, namely, what will be there in the code? From A to I. First, general building requirements, control and regulation. Remember, in the in the second session of this training program, we discussed about building code. So this is the part 3 of the building code, that is architectural part, general building requirements, control and regulation. B, fire protection. This is part 4 of the building code, fire protection. C, building materials. This is part 5 of the building code, building materials. D, structural design. This is part 6 of the building code. E, construction practices and safety. This is part 7. F, building services, part 8. G, alteration, addition to, and change of use of existing building, part 9. H, sign and outdoor display, part 10. So from 3 to 10 is there. I, matters relating to administration enforcement of the above matters. So this is actually part 2 of the building code. So from 2 to 10, this is mentioned here in the act. What about part 1? That is just the scope and the definitions. So to understand these later 9 parts, you have to understand some uh, context. For that, there is another part, part 1. So all the parts from 1 to 10 actually follow exactly uh, the scope that is given in this act. So this is interesting. So for the rules, only this much. BC committee notices, forms, and fees. For the code, all these things, those 10 parts. And the code follows exactly. What about the rules? Vidimala, we'll talk about that. So far, that's it. I have taken about 1 hour to discuss about the BC Act, Building Construction Act. So the Act says that you need permission from the authorized officer of the committee. And if you don't take the permission of, or you do anything against the act, the rules, that is Vidimala, the code, you are punishable, you are counting punishable offense. And the authorized officer and the committee enjoy sweeping powers to ask you to stop construction, to ask you to remove a building. If you don't do that, they themselves can do it and then ask you to reimburse that and make it sure by legal means, realize that money from you, and can sue you, for which you can be punished, maximum 7 years jail term or fee minimum 50,000 or both. And you cannot go to any court. You at most you can appeal. So that's what this PC Act is all about. Let's talk about the Town Improvement Act 1953. So it was enacted in 1953, but it was amended quite a few times. The most important amendment was done in 1987 when RAJUK was formed from DIT, Dhaka Improvement Trust. So the presentation now will include the amendments. So the organization of this act is a bit different from BC Act, Building Construction Act. In BC Act, there are sections and subsections. There are no chapters. But in the TI Act, Town Improvement Act, it is organized in chapters. There are 8 chapters. Preliminary. Second chapter is called the Kotripokko. Third chapter, improvement schemes and rehousing schemes. Fourth, acquisition and disposal of land. 5, rules. 6, finance. 7, again rules. Chapter 8, supplemental provisions. Now, most of the clauses or sections of this act are related to development activities that RAJUK usually does. Land improvement and selling plots to the public, and selling apartments to the public, that type of activities. So this is related to constitution of RAJUK, that is formation of RAJUK and those development activities. So I'll talk only about the formation part. I will not talk about the development activities part because that is not related to this training program, which is mainly related to enforcement of building code. So chapters 3 to 7 don't have anything related to enforcement of building code. So very few things are related to the building code. Now, in the preliminary, here we'll understand what is this act about. The purpose: an act to provide for the development, improvement, and extension of the capital of the Republic and Narayanganj and Tongi municipalities and certain areas in the vicinity, and the constitution of a Kotri-Pokkho, therefore. So the whole purpose is there are two purposes for this act. One is to to provide you the clauses that are required the for Rajuk or the Kotri-Pokkho to I should rather rephrase it. Uh, One purpose is related to formation of the Kotri-Pokkho, that is the authority. The other purpose to provide the Kotri-Pokkho, the authority, with legal tools using which the Kotri-Pokkho can develop land or improve areas of the capital. Now, what is the capital? Dhaka, and nearby areas, Narayanganj, Tongi municipalities. So why isn't it that specific? And certain areas in the vicinity, we'll see that. Why it is not specific here, it will be specific later on, actually in the next clause. The extent. It extends to the areas comprised with the limits of the Dhaka city. So at that time, it was only Dhaka city. It was not DNCC or DSCC, Dhaka city. But the government may, by notification under the procedure prescribed by Section 162, extend this act or any provision thereof to the areas comprised within the limits of Narayanganj municipality and Tongi municipality and such other area in the vicinity of the said city and those two municipalities as may be specified in the notification. So this is not, again, not specific. It can change through gazette notification. So the government may increase the area as the government think appropriate through notification. So that is what exactly what has happened. Now the present jurisdiction of Rajuk is that which we call DMDP area, Dhaka Metropolitan Development Plan area. So that area is defined by notification, gazette notification. It shall come into force in such areas and on such days as the government may by notification specify. So even the government can still extend this DMDP area just by notification. So here you understand purpose and extent. Chapter 2 is related to the Kotri-Pokkho, the authority, constitution of the Kotri-Pokkho, conduct of business, employees of the Kotri-Pokkho. We'll just talk about the constitution of the Kotri-Pokkho. So constitution of Kotri-Pokkho, establishment and incorporation of Kotri-Pokkho. The duty of carrying out the provisions of this act shall, subject to the conditions and limitations hereinafter contained, be vested in a Kotri-Pokkho to be called the Rajdhani Unnayan Kotri-Pokkho, and such Kotri-Pokkho shall be a body corporate and have perpetual succession and a common seal, and shall by the said name sue or be sued. Very, very interesting. The act is primarily written in English, but notice the conscious use of the term Kotri-Pokkho instead of authority. It could be easily written authority, but for some reason, the code writing authority, Ministry of Law, Department of Law, they avoided the English use of English term authority. They intentionally use this Bangla term, Kotri-Pokkho, in the English Act. Why is it so? There must be some reason that the term use of the term authority could have contradicted with some other laws. Maybe that's the reason. But there is a outfall to this. That is, there is a consequence of this. The consequence is that although in this Town Improvement Act it is written Kortripokho, but in the billing there is no mention of Kortripokho. There is only mention of authority. Okay. In the billing code, there is no mention of Kortripokho. There is mention of authority. Now that's why the problem there is a legal problem, or there has been a legal problem. So in the billing code, the responsibility of enforcement of the billing code lies with the authority. In the previous version of the code, in BNBC 2006, it was written the authority. So the authority was responsible for enforcement of the billing code. Who was the authority? There was no authority. There was in case of Dhaka, there is only Kortripokho. There is no authority mentioned in this act or even in the BC Act. So, so there lies the problem. So you cannot just say that this authority is just because the translation of Kortripokho automatically empowers RAJUK for enforcement of the building code. So that problem is now gone with the introduction of BNBC 2020, because in the BNBC 2020 it is clearly written which authority will be responsible for enforcement of the building code. That is BBRA, Bangladesh Building Regulatory Authority. But within the jurisdiction of RAJUK, the authorized officers who will belong to RAJUK, they will enjoy the um, power of the authorized officer or the billing official. So now it is clear. Now there is a relationship. The present BNBC 2020 now relates through this arrangement of BBRA, and under BBRA, in the jurisdiction of RAJUK, the authorized officers of RAJUK will act. In the jurisdiction of CDA, Chittagong Development Authority, the authorized officers of CDA will act. In areas other than CDA, KDA, RDA, the municipality corporations will have authorized officers. In suburban and rural areas, the executive engineers of PWD will be given the power of the authorized officers. So it is clearly written this time. So now no one can say that we don't know who is the authority because it is not written anywhere. It is now clear. But in case of BNBC 2006, it was not clear. It was written authority, but in the act, there is no authority. There is only Kortripokho. So this is interesting. Now, Kortripokho. The Kortripokho shall consist of a chairman and not more than 5 other members. In 1987, when RAJUK was formed, the structure became like this. There will be in the RAJUK, there is a chairman, and there are 5 divisions. Each of the divisions are headed by a member. Previously, during the time of DIT, there was a board of trustees, and the size of the board of trustees was quite big. I don't remember the exact number. Maybe it was, I don't know the number. It was a big board of trustees where there were representations from city corporations, there were representations from other departments. So when RAJUK was formed, it became small. Now, conduct of business, power of creation of posts for the Kortripokho. So when RAJUK was formed as a Kortripokho, it was actually an kind of autonomous body. That is, it can make its own rules for its employees. It can create its own posts for its employees, things like that, like Power Development Board or Water Development Board or Port Authority, Chittagong Port Authority, like that, an autonomous body. But at the same time, with this act, it it is like an authority, but some of the powers are restricted. Let's see. Subsection 34.1. Subject to the provisions of this act, the Kotipokho may determine from time to time which officers and other employees are necessary for the performance of its functions, may also engage such experts and consultants as it may consider necessary for the said purpose, and may fix the salaries, fees, and allowances to be paid to such officers, employees, experts, and consultants. So, like an autonomous body, it can create posts, employ, it can employ experts, consultants, and it is free to fix the salaries, fees, allowances, etc. So completely free, independent. But later, through an amendment, it was written, provided that prior approval of the government shall be necessary for creation of post carrying a pay in a scale of, for some scale, I don't know the exact scale, what it was at that time in 1987, 2800. I don't know the in the present salary scale, which scale does it refer. So for an appointment in a scale higher than this, prior approval of the government is necessary. So his hands are tied. So there are restrictions. But some other things are quite interesting, like delegation of certain functions of chairman. I don't know how much of this is exercised. So far, what I've come to know that this is not exercised, but there is a provision. This is interesting. In section 37(1), it is written, the chairman may, by general or special order in writing, delegate to any member or officer of the Kotipokko any of the chairman's powers, duties, or functions under this act, or any rule or regulation made thereunder, except those conferred or imposed upon or vested in him by sections 27, 29, and 31. So, except these, I'll tell about them. What are these? Except these, the powers mentioned in these sections, the powers and duties and functions of the chairman can be delegated to any officer of the Kotipokko. I don't know how much of this power of delegation is exercised, but if the chairman wants, he or she can delegate all his powers. What is there in 27, 29, and 31? These are related to, like, if Raju goes into any contract, the signing authority will be chairman's authority. The contract, any MOU, any agreement, any notification of award of tender. So the which we call HOPE, that is head of procurement entity. When he's acting as the head of procurement entity, he cannot delegate that power of going into contract with some organization or somebody. There, the chairman has to sign. So that is related to sections 27, 29, 29, and 31 is related to when he has to communicate with the government, like the ministry. When he has to report to the ministry, he cannot delegate that power to anyone else. He has to, the chairman has to report to the ministry, to the government. Except those powers, all other powers can be delegated to any officer of the Kotipokko according to this law. So actually, in the present project S9, which ICC is actually involved in, there are recommendations for using this power of delegation. So I'm not going to that, but just be aware that there is such provision in the Act. In the supplemental provision, this is a little bit out of track, but still I want to mention cooperation of the police. In TI Act, in section 170, subsection 1, it is written, the police commissioner and superintendent of police and their subordinates shall be bound to cooperate with the chairman for carrying into effect and enforce the provisions of this act. So the police commissioner or the SP has to, this is bound to cooperate with the chairman. So the chairman's orders are orders for the police commissioner or the SP. They have to abide by the orders of the RAJUK chairman. 2. It shall be the duty of every police officer who is subordinate to the police commissioner and the superintendent of police. So for any police officer, it is a duty. What? One, to communicate without delay to the proper employee of the Kotipakko any information which he receives of a design to commit or the commission of any offense against this act or any rule or regulation made hereunder. So if a police officer finds anything is going against against uh, what is there in this act, like if Rajuk wants to develop an area, if Rajuk acquires an area, if there is illegal encroachment or things like that, then the police officer, it is the duty of the police officer without any delay to inform uh, a proper employee of the Kotipakko. Second, to assist the chairman or any employee of the Kotipakko reasonably demanding his aid for the lawful exercise of any power vesting in the chairman or any in such employee under this act or in such rule or regulation. So it is saying that if the chairman wants or any employee of the Kotipakko wants, reasonably wants, help from police for some activities, police is bound to offer that help. Now, this is interesting. So all these provisions are under the TI Act. That is an act which is related to development activities, not code enforcement or development control activities. The relevant act for development control or regulatory activities are in the BC Act. In the Town Improvement Act, all the provisions are related to development activities, acquisition of land, etc., etc. For those activities, it is written that the police has to abide by the chairman or any employee of the Kotipakko. But for application of BC Act, that is code enforcement or regulatory activities, development control activities, it is not there in the BC Act that police has to abide by. So for any code enforcement activity, if Rajuk chairman wants something, I don't know, legally there is a loophole that police may deny. But for development activity, if the chairman wants something, the police cannot deny. The police has to abide by it. So this is interesting. Again, this kind of a little bit out of track. Supplemental provisions, penalty for building with street alignment or building line. So this is like encroachment of street or something like that. If any person without the permission of the chairman required by subsection, etc., etc., erects, re-erects, or adds to any wall exceeding 10 feet in height or building which falls within the street alignment or building line of a projected public street shown in any plan sanctioned by the government under the said sanction, he shall be punishable. So if you encroach a street which is shown in the plan, master plan, you are punishable with fine which may extend in the case of this is interesting, with fine which may extend in the case of a masonry building or a wall to 5,000 taka, and in the case of a hut to 500 taka. So you see how outdated these acts are. It just talks about masonry building. It doesn't talk about concrete building or steel building. If you encroach a street with a concrete or steel building, still you may avoid the punishment because this talks about only masonry building. So, or a hut. This is interesting. B, with further fine, which may extend in the case of a masonry building or a wall to 1,000 taka, and in the case of a hut to 100 taka for each day after the first during which the projection continues. This is actually written in this way because probably when the master plan is done, there are some people who want to apply for compensation. So what they do, as soon as the master plan is done, they encroach some part of it. So when the construction for road activities are carried out, and the settlers along those roads, they get compensation. To avail those compensations, some people uh, take this kind of actions. They build a temporary masonry building or a wall or things like that. That's why probably this is like this. But if you were intelligent enough, now we can go and construct a concrete building on the road and you can avoid the punishment. Just joking. Anyway, so that there are many other things in the TI Act, but I have mentioned a few clauses which I found interesting and which I thought may be indirectly related to our topic of building code enforcement. Now I'll go to the uh, most relevant legal document with BNBC is the Imarat Nirman Bithi 2008. Let's see. This is the gazette. I have put two red boxes here. These are two very important statements written here. The first one, from now on, I'll be bilingual because the entire Imarat Nirman Bidhimala is written in Bangla. So I'll read in Bangla all the clauses, and while explaining, I may use English for explanation. So from now on, my presentation will be bilingual. So here it is written that SRO number নং 120 আইন 2008 Building Construction Act 1952 Act number 2 of 1953 or section 18 এর section 18 এ প্রদত্ত ক্ষমতা বলে it's missing ক্ষমতা বলে সরকার নিম্নরূপ বিধিমালা প্রণয়ন করিল. So where from the government derives the power of making this rule? It is written. It is the government, because it is just a gazette, it doesn't go through the parliament. So whatever we do in this country, it must be under some law that is passed through the parliament. Under some act which is passed through the parliament, we can do something. So the government is making these rules through gazette notification. Where from does the government derive this power? It is written from the BC Act, Building Construction, which is passed through the parliament. So that is the basis. So if you remember, when I talked about the Building Construction Act, there was the section 18, which is power to make rules. In that section, it is written, the government may make rules for certain purposes. And this is that rules, this Bidhimala. Do you remember what were the purposes? Number one, constitution of Building Construction Committee. Just for constitute a committee and other things like all the rules that are relevant to the committee. Second, for providing the notices. What would be the manner the notices will be issued for notices. Third, the forms using which you can apply for different types of permit. And fourth, the fees. So these Bidhimala, these building construction rules, this is supposed to cover these things only. The committee, notices, forms, and fees. Nothing else. Nothing else is mentioned in the code, in the Act, BC Act. But you'll find something interesting when you'll go through this Bidhimala. Another box, Town Improvement Act 1953 Act number 13 of 1953 এর অধীন প্রণীত ঢাকা মহানগর পরিকল্পনাভুক্ত এলাকার জন্য প্রযোজ্য হইবে। You remember BC Act is applicable over the entire country, whereas Town Improvement Act is related only to RAJUK, because RAJUK was formed by the Town Improvement Act, and whatever is written there, that is related to the Kotripokho, which is RAJUK. And RAJUK has its own jurisdiction, which is defined through government gazette notification. So it is saying here that Vidhimala will be applicable only within that jurisdiction, this Vidhimala. Although government is making these rules according to the power derived from the BC Act, but the jurisdiction of this Vidhimala will be only the DMDP area. So there are 7 chapters in the Vidhimala. It is also like the Town Improvement Act, it is also organized in chapters. And there are some appendices. So the chapters, let me read out. প্রথম অধ্যায় প্রারম্ভিক preliminaries. দ্বিতীয় অধ্যায় ছাড়পত্র অনুমোদনের আবেদন, অনুমোদন এবং বসবাস বা ব্যবহার সনদ ইত্যাদি. This is related to permits, occupancy certificates. Actually, it is written in the act that those prescriptions regarding these permits will be in the Vidhimala. This is okay. তৃতীয় অধ্যায় committee. So this is the main purpose for the Vidhimala, constitution of the committee. চতুর্থ অধ্যায় কারিগরি ব্যক্তির তালিকা শ্রেণীবিন্যাস ইত্যাদি, enlistment. This is something not prescribed in the act. This is something additional. The act doesn't give the power to make rules for this, but still this is there. পঞ্চম অধ্যায় ইমারত নির্মাণ নিয়মাবলী, construction rules. The act doesn't give this power either, but it is there in the Vidhimala. ষষ্ঠ অধ্যায় স্বাস্থ্য ও নিরাপত্তা, health and safety. The act doesn't talk about anything regarding this to be mentioned in the Vidhimala. The construction practices and safety is there in the code. It is written in the act that it should be in the code, but anyway, in the ষষ্ঠ অধ্যায় health and safety is mentioned there. সপ্তম অধ্যায় বিবিধ miscellaneous. পরিশিষ্ট এক অগ্নি নিরাপত্তা, fire protection out of the blue. The act doesn't say anything regarding this. Fire protection is explicitly written in subsection 18A under powers of making power for making building code. So in the code, in subsection 18A, it is written that there should be a chapter on fire protection, not in the Vidhimala, but it is still there. পরিশিষ্ট 2 সার্বজনীন গম্যতার ন্যূনতম মান, universal accessibility. This is very important, I understand, but it is not supposed to be in the Vidhimala according to the act. It is there. পরিশিষ্ট 3 ব্যবহার ভেদে ইমারত বা শ্রেণী স্থাপনার শ্রেণীবিন্যাস, occupancy type. Again, something additional that is not written in the act. পরিশিষ্ট 4 নির্মাণ অনুমোদন fee. This is relevant. This is written in the act that the Vidhimala should have this. Permit fees, অন্যান্য ফর্ম সমূহ and forms, absolutely okay. But all other things from চতুর্থ অধ্যায় to something additional which is not the Vidhimala is supposed to have. Anyway, still there. Permits, occupancy certificate, etc. ইমারতের নকশা অনুমোদন ও বসবাস উপযোগিতার অনুমোদন পদ্ধতি এই বিধিমালার অধীনে ইমারত, আমি I cannot read some part of it because there is something popping out on my screen. Anyway, উপযোগিতার অনুমোদন পদ্ধতি ক্ষেত্র বিশেষে নিম্নে উল্লিখিত সর্বনিম্ন দুইটি. Okay. Now, there are different types of permits it's talking about. There are 4 types: land use clearance, special project permit for large and specialized projects, building permit, and occupancy certificate. But for you don't need all these for every case. but you need at least two, building permit and occupancy for all the cases, সকল ক্ষেত্রে বাধ্যতামূলক, but the other two প্রযোজ্য ক্ষেত্রে when applicable. So land use clearance. So when land use clearance applicable, ভূমি ব্যবহার ছাড়পত্র, বিশেষ ধরনের প্রকল্পের জন্য ছাড়পত্র ও নির্মাণ অনুমোদনের আবেদনপত্র দাখিলের পূর্বে কর্তৃপক্ষের আওতাভুক্ত কিন্তু পরিকল্পিত এলাকার বহির্ভূত যে কোনো ভূমিতে উন্নয়নের জন্য কর্তৃপক্ষের নিকট হইতে ভূমি ব্যবহার ছাড়পত্র গ্রহণ না করিলে কোনো ইমারত নির্মাণ বা উন্নয়ন কাজ অনুমোদন করা হইবে না. So this is in accordance to the Building Construction Act. That also talks about sanction, but the language is different. That talks about sanction, here it is onumodon. In English is permit. Building code also talks about permit, building permit. So but here, sorry, this is land use clearance, not building permit. I'm sorry, I'm very sorry. So land use clearance, you need land use clearance for areas which are not in the planned area. For example, like in Dhanmondi or Gulshan or Bonani, where under the Rajuk planned area, you need this land use clearance because the plots are all demarcated there clearly. But for other areas, you need land use clearance. গৃহায়ন ও গণপূর্ত মন্ত্রণালয় বা তদধীন কোনো সংস্থা কর্তৃক পরিকল্পিত ও উন্নয়নকৃত কর্তৃপক্ষ কর্তৃক বেসরকারি আবাসিক প্রকল্পের ভূমি উন্নয়ন বিধিমালা 2004 অথবা এতৎ সংক্রান্ত অন্য কোনো বিধিমালা অনুসারে অনুমোদিত বেসরকারি প্রতিষ্ঠান কর্তৃক উন্নয়নকৃত সাইট এন্ড সার্ভিসেস প্রকল্পের অন্তর্ভুক্ত জমির জন্য ভূমি ব্যবহার ছাড়পত্র গ্রহণ আবশ্যক হইবে না. So লাইক বসুন্ধরা আবাসিক area that is private but a housing project, which the project itself has from Rajuk, so you don't need additional land use clearance for constructing your building on a plot because the whole housing project is already permitted land use clearance. But for the project unit permission, let's read that here. Special project permit for large and specialized projects, বৃহদায়তন বা বিশেষ ধরনের প্রকল্পের জন্য বিশেষ প্রকল্প ছাড়পত্র, নিম্নলিখিত ধরনের প্রকল্পের জন্য বিশেষ প্রকল্প ছাড়পত্র গ্রহণ করিতে হইবে, যথা 40টির অধিক আবাসন ইউনিট বিশিষ্ট আবাসিক ভবন, so like large apartment complex, মোট 7,500 বর্গমিটারের অধিক ফার আওতাধীন মেঝে বিশিষ্ট যে কোনো প্রকল্প. Now what is FAR? FAR is floor area ratio. So I'll not go into the detail of these because this will be covered when the architectural issues will be presented to you by architect Zia in a later session in this training program. He will explain. But there is a concept of floor area ratio that is mentioned in this Vidhimala and in the code, building code. So, so if the floor area is more than 7,500 square meters, in that case, you'll need this special project permit. মোট 5,000 বর্গমিটারের অধিক ফার আওতাধীন মেঝে বিশিষ্ট বিপণী কেন্দ্র. If it is a market, then if it is more than 5,000 square meter area, floor area, then you have to apply for special power project. জাতীয় আঞ্চলিক মহাসড়ক বা প্রধান সড়কের সহিত সরাসরি সংযোগ বিশিষ্ট যে কোনো প্রকল্প. So if your project is just adjacent to a highway, N1 or N2 highways, then you have to take permission of the special project permit. ইটের ভাটা সহ বিশেষ ভাটা সহ পরিবেশ দূষণমূলক বা বিপজ্জনক শিল্প কারখানা for industries which may pollute air. You just excuse me for a few seconds. I'm sorry. That was not one. Bye. So I got a complaint that some of you may not hear me properly. Dr. Prabhuto, Maria, can you hear me?
I can hear you.
We can, and some people have. I think only two have
Ah,
commented
okay.
in the Q&A area, but I guided them to do something to fix the issue. But I think the issue is on their side.
I see. I see. Okay. Okay. Okay then. So the next is, so if you're going to construct some industrial facility where there may be some risk of air pollution, you have to take permission. This permit, special project permit. স্থাপত্যিক বা ঐতিহাসিক গুরুত্বপূর্ণ ভবন বা এলাকার 250 মিটার দূরত্বের ভিতর যে কোনো নির্মাণ, but if you have some archaeologically important site, historically important site uh, nearby your construction, you have to take this permission. প্রাকৃতিক সৌন্দর্যমণ্ডিত এলাকার 250 মিটারের দূরত্বের ভিতর যে কোনো নির্মাণ বা উন্নয়ন, if you are constructing very close to a reserve forest, for example, then you have to take permission. পাহাড়ি এলাকা বা পাহাড় হিসেবে দৃশ্যমান জমিতে অথবা এইরূপ ভূমির 50 মিটারের মধ্যে যে কোনো ধরনের নির্মাণ, if it is close to some hill area or hill, নদী তীরবর্তী 250 মিটারের দূরত্বের মধ্যে, so if it is just by the side of the river bank, then you have to take the permission. So this is special project permit. You don't always have to take this permit, but you have to take this permit for sure, building permit. This is important. Oh, sorry. নির্মাণ অনুমোদনপত্র 1, কোনো ব্যক্তি বা সরকারি বা বেসরকারি সংস্থা নতুন ভবন বা অবকাঠামো নির্মাণ করিতে বা I can read this, ভবন বা অবকাঠামো পরিবর্ধন বা সংযোজন করিতে ইচ্ছুক হইলে আইন অনুযায়ী নির্মাণ অনুমোদন পত্র গ্রহণ করিতে হইবে. So who needs this building permit? Not only individuals, not only private organizations, not only non-government organizations, even all the government organizations, if they want to construct a building, they have to apply for building permit. আবেদনকারী এবং বিধি 41-এর আওতায় প্রণীত তালিকা মোতাবেক যথাযথ যোগ্যতা সম্পন্ন কারিগরি ব্যক্তিবর্গ নকশায়ন অমুদ্রিত স্বাক্ষর প্রদান করিবে এবং কারিগরি ব্যক্তিবর্গকে তাহাদের পেশাজীবী সংগঠনের সদস্য নম্বর ও রেজিস্ট্রেশন নম্বর নকশা ও দলিলাদির নির্ধারিত স্থানে উল্লেখ করিতে হইবে. আচ্ছা, ওকে, this is important. It is written that যথাযথ যোগ্যতা সম্পন্ন কারিগরি ব্যক্তিবর্গ, professional individuals with experiences, appropriate experiences or qualification. So how do you know that who has the qualification or not? It is mentioned there. So there is a list where we can find who is qualified for what job. There is a table for that. But this is important that if you are an engineer for designing or supervising a construction or anything, you have to have membership number of IEB, Institute of Engineers Bangladesh. Or if you're an architect, then you have to have a membership number of IAB and registration number. That is again for specific cases like there is enlistment. It talks about enlistment. There is a provision for registration number. You have to have that too. We'll see. Duties and responsibilities of the applicant. So whoever applies for the building permit, what are the duties and responsibilities? নির্মাণ সংশ্লিষ্ট বিষয়ে আবেদনকারীর দায়িত্ব ও কর্তব্য প্রকল্পের নির্মাণ কাজ বিধি 43-এ উল্লিখিত সারণী 1-এর বর্ণনা মোতাবেক কারিগরি দক্ষ ব্যক্তিবর্গ দ্বারা তত্ত্বাবধান করাইতে হইবে. So it is the responsibility of the applicant to make sure that all the professional activities are done by professionals with adequate qualification, as mentioned later. ৩. কাজ শুরু করিবার অন্তত 15 দিন পূর্বে নির্ধারিত ছক ফর্ম ৩০৭ এর মাধ্যমে কর্তৃপক্ষকে লিখিতভাবে কাজ শুরু করিবার অথবা স্থগিত কাজ পুনরায় শুরু করিবার ইচ্ছা জানাইয়া নোটিশ প্রদান করিতে হইবে, যাহাতে নির্মাণ কাজের সাথে সংশ্লিষ্ট ব্যক্তি বা ব্যক্তিবর্গের প্রত্যয়ন বা সম্মতি স্বাক্ষর থাকিতে হইবে। This is interesting. You cannot just arbitrarily change the professional. Sorry, this is about restarting. You have to always inform the authority, কর্তৃপক্ষ, about stopping any work when you are starting, things like that. And the fourth one is regarding changing professionals. প্রকল্পে নিয়োজিত কোনো কারিগরি ব্যক্তিকে নতুন নিয়োগ অথবা পরিবর্তন সম্পর্কে নির্ধারিত ছক ফর্ম 309 এর মাধ্যমে কর্তৃপক্ষকে 15 দিনের মধ্যে লিখিতভাবে জানাইতে হইবে এবং কারিগরি ব্যক্তি পরিবর্তনের ক্ষেত্রে নতুন নিয়োগপ্রাপ্ত কারিগরি ব্যক্তির দায়িত্ব গ্রহণ না করা এবং তার সম্মতি কর্তৃপক্ষকে না জানানো পর্যন্ত নির্মাণ কাজ স্থগিত থাকিবে। So you cannot just arbitrarily change professionals. You have to inform the authority using a certain form number 308. In that case, the person who is taking the responsibility, the professional, he has to inform the authority his consent that he is taking that responsibility. Otherwise, they cannot continue with the construction. Duties and responsibilities continued. ইমারতের প্লিন্থ পর্যায় পর্যন্ত কাজ সম্পূর্ণ হইলে উহা আবেদনকারীকে নিয়োজিত কারিগরি ব্যক্তিবর্গের প্রতিবেদন সহ নির্ধারিত ছক ফর্ম 309 ও ফর্ম 310 এর মাধ্যমে কর্তৃপক্ষকে অবহিত করতে হবে। So this is specifically mentioned in the Vidhimala that once you construct up to the plinth level, then you have to inform the কর্তৃপক্ষ with reports from the professionals. This is important. Why? Because it is related to how much of land you are actually using. So that ensures the maximum ground coverage, that maximum how much ground you are allowed to cover. And there is a mandatory uncovered area, whether you are leaving the mandatory area that is supposed to be uncovered, that you cannot cover with concrete. It has to be green. So to make these things sure, this provision is there that when you have constructed up to the plinth level, you have to report to the authority. Then the authority will inspect the next clause. প্লিন্থ লেভেল পর্যন্ত নির্মাণ সম্পন্নকরণ অবহিত হওয়ার পর কর্তৃপক্ষ তাহা পরিদর্শনের ব্যবস্থা করিবে এবং 7 দিনের মধ্যে প্লিন্থ স্তর পরবর্তী নির্মাণ কাজ অগ্রসরের জন্য নির্ধারিত ছক ফর্ম 311 এর মাধ্যমে সম্মতি অথবা কারণ সহ নির্ধারিত ছক ফর্ম 312 এর মাধ্যমে অসম্মতি প্রদান করিবে, অন্যথায় নির্মাণ কাজ চলিতে থাকবে। So this is interesting that the কর্তৃপক্ষ will then inspect, and if the কর্তৃপক্ষ is not satisfied within 7 days, it has to inform you. If it is satisfied, still it will inform you, but if fails to inform, you can carry on with your construction work. This is related to safety and monitoring. I am skipping many clauses. I'm just informing those, mentioning those that I think is relevant for this evening. But if you are interested, you should read all the clauses. Safety and monitoring. 17. নির্মাণ সংশ্লিষ্ট নিরাপত্তা ও তদারকি এক নির্মাণ স্থল এবং তার চারপাশে প্রয়োজনীয় যথোপযুক্ত নিরাপত্তা ব্যবস্থা থাকিতে হইবে. So I'm not very sure either it talks about safety or security, because you can translate nirapotta in both ways. You can mean security or safety, but as it appears that it talks about safety. টু, যদি নির্মাণ কাজ কোনো রাস্তায় বা স্থানে জনসাধারণের জন্য বাধা, বিপত্তি অথবা অসুবিধা সৃষ্টি করে, তাহলে আবেদনকারী কর্তৃক উক্ত স্থানে অস্থায়ী ঘের, জীবন রক্ষাকারী বাধা, শিল্ড এবং বিকল্প চলাচল পথ তৈরি করিয়া জনসাধারণের নিরাপত্তা নিশ্চিত করিতে হইবে। So it is there in the code and in detail with dimensions, but this is simply repetition of what is there in the code. তিন, নির্মাণ প্রকল্পের দ্রব্যাদি ও জিনিসপত্র জনপথে কিংবা ফুটপাতে রাখিয়া জনসাধারণের চলাচলে অসুবিধা সৃষ্টি করা যাইবে না। এগেইন দিস ইজ দেয়ার ইন দ্য কোড, দিস ইজ জাস্ট রিপিটিশন। চার, আবাসিক এলাকায় সন্ধ্যা 6টা হতে সকাল 6টা পর্যন্ত কোনো যন্ত্রপাতি ব্যবহার বা নির্মাণ পদ্ধতির মাধ্যমে নির্মাণ সাইট বা প্রকল্প স্থলে বিরক্তিকর কোনো আওয়াজ বা পরিস্থিতির সৃষ্টি করা যাইবে না, এবং দিনরাত্রি কোনো সময় এই সাইটে পাথর বা কোয়া ভাঙানো মেশিন ব্যবহার করা যাইবে না। So this is specific about stone breaking machine tool, but in general these are simply repetitions of what is there in the code in detail. These provisions are there in the code with many more details and holistically. These are some provisions, um, very how to say, brief statements of something which is which you should be more elaborate about. So first of all, this was safety and monitoring, তদারকি, নিরাপত্তা ও তদারকি. It is not supposed to be in the Bidhimala according to the BC Act, but it is there and it is repeating some of the clauses from the code. I'm just pointing out what are the anomalies there in between the Bidhimala and the Act. You just have to be aware of that, but we cannot do anything about it. There is an ongoing process of updating this Bidhimala. I hope the people who are involved there in updating the Bidhimala, they will look into this. Occupancy certificate. This is important. বসবাস বা ব্যবহার সনদপত্র, occupancy certificate. এক, ইমারত আংশিক বা সম্পূর্ণ নির্মাণ সম্পন্ন হইবার পর ইহার ব্যবহার বা বসবাসের জন্য বসবাস বা ব্যবহার সনদপত্র গ্রহণ করিতে হইবে। In the act it is saying that if you use a building improperly, that violating the provision of the building permit or the master plan, if you use it improperly, then that is a punishable offense. And the use, when you can use it, that will be here. By when you can avail the occupancy certificate, then only you can start using a building partially or completely. দুই, বসবাস বা ব্যবহার সনদপত্রের গ্রহণের জন্য আবেদনপত্রের সহিত নিম্নলিখিত দলিল ও নকশাদি কর্তৃপক্ষের সংরক্ষণের জন্য দাখিল করতে হবে, যথা completion report, সমাপ্তি প্রতিবেদন, so that your construction has been completed and there has been inspections and you have a completion report that the construction has been completed satisfactorily, following all the rules. খ, কর্তৃপক্ষ কর্তৃক অনুমোদিত স্থাপত্য নকশার ভিত্তিতে নির্মিত ইমারতের নির্মাণ নকশা, as built architectural drawing. You have to submit this as built architectural drawing. ইমারতের কাঠামো নকশা, structural design. Now it is saying during the in the building approval process, in the building permit, while you are applying for the building permit, it doesn't talk about structural design, but for occupancy certificate you have to submit structural design. এবং ইমারত সেবা, বিল্ডিং সার্ভিসেস সংক্রান্ত সকল নকশা, বিল্ডিং সার্ভিসেস ডিজাইন, ইলেকট্রিক্যাল, মেকানিক্যাল ডিজাইন। উপবিধি 2 এ উল্লিখিত সকল নকশা ডিজাইন পর্যাপ্ততা, ডিজাইন অ্যাডিকুয়েসি ও উপযুক্ততার যাবতীয় দায়িত্বভার নকশার সহিত সংশ্লিষ্ট পেশাজীবীদের, স্থপতি বা প্রকৌশলী উপর বর্তাইবে। So all the responsibilities, the Vidhimala says, all the responsibilities lie with the professionals regarding this. So this is all about occupancy certificate. So in the beginning, the Vidhimala talks about 4 types of certificates or permits or sanctions, whatever you call it. The number 1 is land use clearance. only in applicable cases. Number two, special project permit, only you need for applicable cases. Number three, building permit. You always have to apply for this and avail this. So building permit. And number four is occupancy certificate. After completion of construction, then before you are eligible to use it, you have to avail this occupancy certificate. But interestingly, in Dhaka, in the Rajuk area, very few in negligible cases, the owners have the occupancy certificate. In most of the cases, the owners, they don't have occupancy certificate. And some owners have applied for occupancy certificate, but couldn't get one. I don't know the details, but this is the situation. Probably as if hard that only 3% buildings, or in very few cases, the owners have this occupancy certificate. So according to the Building Construction Act, the entire population of Dhaka are committing an offense by using their buildings without occupancy certificate, which is punishable. The offense is punishable by law, maximum 7-year jail term or minimum 5,000 taka fine or both. This is interesting, isn't it? So that is all about occupancy certificate. Then completion certificate. To apply for the occupancy certificate, you need this completion report, actually, not certificate. I made this. This is my mistake. This is my translation. 19 সমাপ্তি প্রতিবেদন. So there is completion report. এক, নির্মাণ প্রকল্পের আংশিক অথবা সম্পূর্ণ কাজের উপর আবেদনকারী নির্ধারিত ছক ফর্ম 401 এর মাধ্যমে একটি সমাপ্তি প্রতিবেদন দাখিল করিবেন এবং কর্তৃপক্ষের নিকট উক্ত প্রকল্পের আংশিক কিংবা সম্পূর্ণ বসবাস বা ব্যবহার সনদপত্রের জন্য আবেদন করিবেন এবং কর্তৃপক্ষের নিকট হইতে আংশিক বা সম্পূর্ণ বসবাস বা ব্যবহার সনদপত্র লাভ করিবার পূর্ব পর্যন্ত উক্ত ইমারত বা কাঠামো আংশিক কিংবা সম্পূর্ণ কোনো অবস্থাতেই ব্যবহার করা যাইবে না, কিন্তু আমরা সকলেই ব্যবহার করছি। This is the fallacy. So the thing is that to apply for occupancy certificate, you need this completion report. But who will prepare this? The building owner will prepare these with the help of the professionals, and the building owner will prepare the completion report and submit it with the application for occupancy certificate. 2, নিয়োজিত কারিগরি ব্যক্তি বা ব্যক্তিবর্গ নির্ধারিত ছক ফর্ম 402 এর মাধ্যমে প্রত্যয়নপত্র প্রদান করিবে এবং উক্ত প্রত্যয়নপত্রে নির্মাণ কাজ নির্ধারিত নিয়ম অনুযায়ী তাহার বা তাহাদের তদারকিতে সম্পন্ন হইয়াছে ইহার উল্লেখ থাকিতে হইবে। So there has to be supervision, which is written in the code too. That supervision is not a choice. This is a compulsion on the part of the owner. There has to be people who will supervise, professionals who will supervise the construction, and they will certify that the construction has been according to the standards. I don't know, niyom অনুযায়ী. So what is the definition of niyom? The rules, maybe বিধিমালা. 3, নিযুক্ত কারিগরি ব্যক্তি বা ব্যক্তিবর্গ তাহার দায়িত্ব পালনকালীন সময়ে যে যে কাজের তদারকি করিয়াছেন তাহার তদারকি প্রতিবেদন দাখিল করিতে হইবে। So electrical, someone who will supervise the electrical wiring and electrical stuff, he will certify only for that. Someone who will supervise the mechanical parts, he will certify only for that. Someone who will supervise for plumbing, he will certify only for plumbing. So relevant people will certify for relevant works. 4, কর্তৃপক্ষ আবেদনকারী ও কারিগরি ব্যক্তিগণের উপস্থিতিতে আবেদনপত্র প্রাপ্তির 15 দিনের মধ্যে ইমারতটি পরিদর্শন করবেন। Inspection comes here. So once the application with the completion reports is submitted to the কর্তৃপক্ষ, then কর্তৃপক্ষ will arrange for inspection. ইমারতটি অনুমোদিত নকশা মোতাবেক ইমারতটি অনুমোদিত নকশা মোতাবেক নির্মিত হইয়াছে কিনা তা পরীক্ষান্তে লিপিবদ্ধ করা হইবে এবং পরিদর্শনের 15 দিনের মধ্যে নির্ধারিত ছক এর মাধ্যমে সম্পূর্ণ ইমারতের নকশা অনুমোদন সহ বসবাস বা ব্যবহার সনদপত্র প্রদান করা হইবে। So this is another binding responsibility on the part of Raju, that they have to issue the occupancy certificate within 15 days of application, but that's not happening. So this is it. Now, I know we engineers are all interested about structural design. What is written about structural design in the Imarat Nirman Vidhimala? 21 ইমারতের কাঠামো নকশা, স্ট্রাকচারাল ডিজাইন এক, এই বিধিমালার আওতায় তালিকাভুক্ত ও আবেদনকারী কর্তৃক নিয়োজিত প্রকৌশলী কোড অনুযায়ী ইমারতের কাঠামো নকশা যথাযথ স্কেলে প্রণয়ন করিবেন। So this is the first time in the Vidhimala the mention of code is there. So প্রকৌশলী কোড অনুযায়ী, in the definitions part of the Vidhimala, by code it is written that by code we will understand Bangladesh National Building Code. So here it is saying that all the designs, particularly for structural design, must be according to the building code. There is a special mention of seismic design. 2 প্রযোজ্য ক্ষেত্রে কোডে প্রদত্ত নীতিমালা অনুযায়ী seismic design বিবেচনায় রাখিয়া কাঠামো নকশা প্রণয়ন করিতে হইবে। So this is interesting. We design not only for earthquake load, for wind load, and for all other different types of load, but in the Imarat Nirman Vidhimala, only seismic design is specifically mentioned to give some emphasis, probably. Anyway, 3 ইমারতের কাঠামো নকশায় নিম্নলিখিত বিষয়াদি অন্তর্ভুক্ত থাকিবে যথা, I'm running out of time, so maybe I should skip some of the things. So soil test report should be there, foundation design must be there. So when you will submit these, when you will apply for occupancy certificate with the completion report, only then you need to supply this. But later in other notifications, things became different, like for their conditions for high-rise buildings above 9 story, then you have to apply with, for building permit you have to apply with structural design, but those things are written elsewhere in some notifications. But in the Vidhimala, you are supposed to submit structural design only for occupancy certificate, not for building permit. So for building permit, you just prepare the plan, the architectural plan, you construct the building, and later then you submit the structural design. This is the scheme of Vidhimala. Basement, there, etc., etc. So there has to be like sewage system, plumbing, all these things should be there in the design. But under the heading of structural design, these things are written. That is interesting. Imarat Sheba, billing services. So here it is, sorry, I'm wrong. There only ভূমিখনন পাইপলাইন বসানোর ক্ষেত্রে সংযোগ সাইটের ক্ষতিগ্রস্ত etc. Foundation, related to foundation, but there is septic tank, these things are mentioned. But in the services again, পানি সরবরাহ, পয় নিষ্কাশন, drainage, gas, these will be there. Electrical substation, these designs must be there. Air conditioning. So all the billing services designs, you have to submit it for occupancy certificate. And the occupancy, the validity of the occupancy certificate is not the eternity. You have to renew the occupancy certificate every 5 years. And so whenever you apply for occupancy certificate, there is supposed to be an inspection. So after every 5 years, there is supposed to be some inspection. And there is provision when you need lift, elevator. So there is validity for building permit too, 3 years. So what does it mean? It means that if you apply for building permit, you obtain a permit, but within 3 years you don't construct anything. You leave the plot vacant without construction. then you have to apply again for the building permit. So this is important, committees. Oh, I have many more things to cover. Sorry, I'll go a little bit fast now. So committee, সরকার গ্যাজেট প্রজ্ঞাপন দ্বারা এই বিধিমালার বিধানসমূহ প্রয়োগের উদ্দেশ্যে নিম্নরূপ এক বা একাধিক কমিটি গঠন করিতে পারিবে। ইমারত নির্মাণ কমিটি, বৃহদায়তন বা বিশেষ প্রকল্প অনুমোদন কমিটি, নগর উন্নয়ন কমিটি এবং প্রয়োজনীয় অন্য যে কোনো কমিটি। So there are names of few committees that are mentioned in the Bidhimala that the government is supposed to form through notifications. Imarat Nirman Committee, which one is written in the BC Act, that is referred here. By Ain, it refers to BC Act in this Bidhimala. It is defined like that. Ain section 3, here subsection 2, where the committee is mentioned in the BC Act. Instead of authorized officer, the committee will act. That clause. এর বিধান অনুযায়ী অথরাইজড অফিসারের ক্ষমতা প্রয়োগের জন্য এক বা একাধিক ইমারত নির্মাণ কমিটি গঠিত হইবে এবং কমিটির কার্যকরিতা উক্ত আইনের আওতায় নিয়ন্ত্রিত হইবে। So whatever there is in the act, that will be performed by this BC committee. So there will be another committee, বৃহদায়তন। এই বিধিমালা আওতায় বৃহদায়তন বা বিশেষ ধরনের প্রকল্প অনুমোদনের জন্য কর্তৃপক্ষ একটি বৃহদায়তন বা বিশেষ প্রকল্প অনুমোদন কমিটি to approved special project permits, that will be, those applications will be judged by this committee, বৃহদায়তন বিশেষ প্রকল্প কমিটি, অনুমোদন কমিটি। There is another committee, Town Improvement Committee. Don't mix it up with Town Improvement Act. This is different. This is mentioned in Bidhimala, which is under BC Act, but the name of the committee is Town Improvement Committee. নগর উন্নয়ন কমিটি, ঢাকা মহানগরী অবকাঠামো উন্নয়ন কার্যক্রম সমন্বয়, পরিকল্পনা, প্রণয়ন, পরিবহন ব্যবস্থা উন্নয়ন, নিয়ন্ত্রণ, বাস্তবায়নের সার্বিক সহায়তার জন্য সরকার নির্দেশী আদেশ বা প্রজ্ঞাপন জারির মাধ্যমে সংশ্লিষ্ট সরকারি কর্মকর্তা, বিশিষ্ট নাগরিকবৃন্দ ও বিশেষজ্ঞদের সমন্বয়ে একটি নগর উন্নয়ন কমিটি গঠন করিবে। নগর উন্নয়ন কমিটির কার্যাবলী হইবে নিম্নরূপ: সকল উন্নয়নমূলক উন্নয়ন কাজের নীতি ও ভবিষ্যৎ রূপরেখা সুপারিশ করা, ইমারত নির্মাণ বিধিমালার সহিত নির্মাণ ও উন্নয়ন কাজের সংগতি তদারকি করা, আওতায় এই বিধিমালার আওতায় নিষ্পত্তিযোগ্য নয় এমন সকল বিষয়ে দিক নির্দেশনা প্রদান করা, রাজুকের মহাপরিকল্পনাভুক্ত এলাকায় সকল ইমারত নির্মাণ কর্মকাণ্ডের গুণগত মান, স্বচ্ছতা ও জবাবদিহি নিশ্চিত করা, বিধিমালা বাস্তবায়নে ন্যায় ও সমতা বিধান করা এবং the last one is very important, most important, আপিল নিষ্পত্তি করা। In the BC Act, you remember there is a provision that if anyone is if there is any allegation against anyone, the defendant can resort to some appeal, that he or she can appeal, because he or she cannot go to any court, civil court. Only thing he or she can do is to appeal. To whom he or she will appeal? This is the appellate body, Nogor Unnayan Committee, Town Improvement Committee. This is the committee who will judge your appeal. So this is important. Now, I talked about professionals with at relevant qualification or appropriate qualification. So this is the table which mentions about the qualifications. Here, the buildings are categorized depending on the height and the area and occupancy type. No, sorry. Right, occupancy type. Based on that, the relevant professionals, their qualification is mentioned here. So the first one is buildings up to 5-storied. So this is different from the table we found in the building code. In the building code BNBC 2020, there is a similar table, but the classification is different, building classification is different, and the professionals and the qualification is different. So there has to be now in the updating, during the updating of the Vidhimala, it has to be consistent. So right now it is different. It has relation with building occupancy, but in the code, that table doesn't have any relation with building occupancy. So that's it. I'll just skip. So I talked about mandatory uncovered area that is mentioned here. It talks about maximum ground coverage and floor area ratio and parking facilities. But these are all mentioned even in the code, building code. So these are either repetitions or some duplication. There, in some cases, there are contradictions. And first of all, these are not supposed to be in the Vidhimala according to the BC Act. Interestingly, what is written here, priority, বিধিমালার প্রাধান্য, এই বিধিমালা ও কোডের মধ্যে কোনো প্রকার বিরোধ বা অসঙ্গতির ক্ষেত্রে এই বিধিমালা প্রাধান্য পাইবে, তবে যে সকল বিষয় দিয়ে বিধিমালা সুস্পষ্ট উল্লেখ নাই সেই সকল ক্ষেত্রে কোডের বিধানাবলী প্রযোজ্য হইবে. So this is interesting. If there is any conflict between the code and the vidhimala will prevail. Whereas there shouldn't be any duplication because the scope is clearly defined in the BC Act and the scope is completely different. But while preparing this Vidhimala, it is prepared in such a way that there are overlaps with the code. And that's why you need this clause. So in many cases in the Vidhimala and in the Act, it is mentioned that the government will come with some notifications, will issue some notifications for specific purposes. One of those purposes is the BC Act, formation of BC Act. So in the notifications, government talks about, or government has formed 3 types of BC committees. One is one-man committee. Only the authorized officer is the committee. For what type of building? It is written in column 5. For low-risk residential, sorry, low-risk store and warehouse. For these structures is written in detail in column 5. For those structures, authorized officer himself or herself is the committee, one-man committee. For other structures, these are called low-risk structures. For except low-risk structures up to 8-story height, below 9-story, there will be committees, BC committees, 3 committees for each of 8 zones. There are 8 zones in Dhaka. Dhaka is divided in 8 zones, Rajuk zones. For every zone, there will be 3 committees, BC committees. And these committees will be headed by the zonal director, and authorized officer will be the member secretary. And there will be 3 other members. If your structure is more than, is 9-storied or above, then there are special 2 committees, which committees are with Rajuk headquarters. They are not in any specific zone. So in anywhere in Dhaka, if you want to construct a 9-story building or above, your application will go to the Rajuk headquarters, not in that zone. And there are 2 committees who will judge those applications. One committee headed by member planning, and the other committee by member development committee control. And both the committees have 5 members, each with authorized officers as member secretary. So this is the formation now. So the building committees we are talking about. So these are the committees. So low risk structures, authorized officer as mentioned in the BC Act. Authorized officer can enjoy all the powers mentioned in the BC Act. For other cases, not low risk structures, then there are different committees. And for large and special special project, for the Onumodon approval of large or special project, there is a special committee headed by member planning with 7 members, etc. It's all written. And what are the special projects? It is mentioned here again in column 5. It is similar to what is written in the Vidhimala. And the Bidhimala also talks about Town Improvement Committee. It was gazetted by notification in 2008. So this is the composition. This is a high-level committee where headed by the Secretary of Ministry of Housing and Public Works. So this is the composition of the Nagar-Unnayan Committee. This is the appellate body. And appellate subcommittee of the this is the this Nagar-Unnayan Committee does all the activities that are mentioned in the Vidhimala. For appeal resolution purposes, there is a subcommittee, appellate subcommittee, that was formed in a gazette notification in 2019. That is headed by Chairman Raju, and some other members are there as mentioned here. So Rajuk construction approval process is shown here. It's a long process. I'm not going into the detail of this because I'm running out of time. So you can see this. It is, I think, self-explanatory. So this is important. This is for simplification of plan permit system. So for control, sorry, for sorry, for special project or for high-rise structure, you were supposed to take permission from different organizations previously. NOC, it was called No Objection Certificate for 11 organization. That has been simplified by Gazette notification in March 2019. So you can read it. I hope you have the printout of this presentation there. It is self-explanatory. So you don't need no NOC from say FSCD if it is not 10 stories or higher. You don't need no NOC from the DOE if that is not applicable. Sorry. For example, if you don't need NOC from air aviation, what is called civil aviation, if your structure doesn't fall into air funnel, things like that. Previously, all the applications used to go to 11 organizations. That has been simplified by this order. This is kind of repetition. I'll skip these, And for construction monitoring process, that is like inspection. Once you apply for building permit, once you start construction or up to plinth level, there are stages of inspection. How the inspection activities are carried out, the process is given here. Now the fire safety inspection, this is important. I want to spend a few minutes on this. Fire safety inspection, where does it come from? It is the power responsibility of fire safety inspection is given to the Fire Service and Civil Defense (FSCD) by a notification, gazette notification, if a structure is more than 10 stories or 33 meters, then FSCD will inspect for fire safety. This is not given by BC Act. This responsibility is not given by the code. Rather, the building code says that the authority, that is the authority, building official, is the person. This is the responsibility of the building official, that is the authorized officer, who will make sure that proper fire safety is there. That is, whatever is written in the building code, the fire safety provisions are followed in a specific building. It is the responsibility of the building official or the authorized officer. But by government notification, the power has been given to fire safety and fire service and civil defense. Actually, fire service and civil defense is under the Ministry of Home. Their activities are regulated by the Fire Safety Act, which is a different act. that is related to existing buildings. In the existing buildings, how much explosives you can keep, how much flammable things you can keep, things like that. So their mandate is to ensure that you are using certain infrastructure according to the Fire Safety Act. That is a different act, not the Building Construction Act. Under the Building Construction Act, in the Bangladesh National Building Code, anything related to fire safety of an under construction building, that is a building that is not there, it will be there, would be building. That belongs to the authorized officer or building official. So whenever you apply for um, building permit, in the plan approval process, in the inspection process, the building official or the authorized officer will ensure that the fire safety provisions are there in the design, during inspection, in the construction. So it is the mandate of the building official or the authorized officer, not FSCD. FSCD's mandate is to ensure that you are following Fire Safety Act. That's a different act, not Building Construction Act. So there is a misunderstanding about all these. So you just have to be aware of this. So that's why in this project, ICC is recommending these changes, that how the plan review process should be conducted. All structural plan, architectural plan, fire safety plan, and building services plan should be reviewed. And how they can be reviewed, the recommendations are there. And even for inspection, there are certain recommendations. Who will inspect, how they will inspect, what should be the qualifications. And these are recommended in this project by the ICC in detail. So I just mentioned that, and recommendations regarding issues. So I'm not going to these. So I finish my presentation here. Thank you for your patience. If you have any questions, please write the questions in the question and answer box. I'll try to answer. I would request Mr. Shohidul Alam, ex-secretary of the Ministry of Housing and Public Works and ex-chairman of RAJUK, to help me in this question answer session. As you can understand that I'm not a qualified person to answer all of your questions regarding these legal matters. Thank you so much.
So it appears we do have a number of questions, and today all questions are in the Q&A box. So you can.
Okay.
Although you'll have to ignore some of the questions that are related to some people having audio issues. So just ignore those areas. I have already responded. But,
thank you.
Sure.
Okay. So the question answer box, in the question answer box, I find that someone has asked, during design a building with stiffness modifier value, we should use during analysis as well as designing, I cannot read it, framing object according to BNBC 2020. I didn't get the question, and it is not related to today's presentation, but we'll consider that this, we will keep this in our record and we'll try to answer you back. I think this is related to some other session, which will be covered by Dr. Ghosh. I'm not, sorry. So, do the construction industry really follow the duties and responsibilities from 308? If not, what penalization may one face? So I don't know. I shouldn't judge. All of you are professionals. You can see if the construction industry really follows all the duties and responsibilities mentioned in the form 308. But if someone violates these responsibilities, so they're violating Vidhimala, so which is the rules under BC Act. So in a way, they're violating BC Act. And if someone violates BC Act, he or she is committing an offense which is punishable by the Act. And you know the punishment: maximum 7-year jail term, imprisonment, or fine, minimum 5,000, 5,000 taka probably, or both. So you know it. Outside the Purosabha, is it necessary to permit the building design? If it is necessary, who is the authority? Very good question. It is there in the building code, BNBC 2020, is in part 2, in chapter 3. It is written there that it will be under the jurisdiction of the executive engineer of the PWD in that area. So the executive engineer of PWD will enjoy the power and duties of an authorized officer for areas outside Purushabha. Sir, what will be
Dr.
the
Rakib,
setback provision? Yes.
I'm sorry, I think
Sorry.
you skipped one question. You missed one question. I'm not sure
For
what
construction,
you mean. Yes.
who will be responsible for?
Right.
Which construction? For construction, who will be responsible for?
Yeah, the question is not clear to me either. But it's part of the point.
But there is another question. Sir, please refer some textbook to get information regarding dynamics of building, response analysis, etc. There are many textbooks. My favorite is Chopra, Anil K. Chopra. So I'll suggest you read on the textbook of Anil K. Chopra for structural dynamics. Then, sir, what will be the setback provisions in case of a building to be constructed beside a private road, not public? So, if it is, I'm not sure. Alam Bhai, are you there? Help me out in this. Alam Bhai was having problem with his audio. I'm not sure if you can hear me.
Alam bhai, if you can hear us, you will need to unmute yourself. There is a mute, unmute button near the bottom of your screen.
Yeah. I think the question is in colony 3, table 3. It has to be left in private road for construction of a building. There is a clear-cut table in Imarat Nirman Vidhimala, table 3 call. There's a detailed list of the, depending on the width of the road, you have to determine how much area you have to leave in front, like that.
So it doesn't matter if it is private or public, right?
No.
As long as that one is designated as road in the plan, master plan probably.
Yeah, in case of private road, you have to follow that. In future, if the master plan is implemented, then the road width may go wider, and you have to consider the wider road, and you have to leave that portion in addition to your private road. Say your private road is 10 feet. Now in the master plan, it said the road will be eventually 20 feet. Then you have to keep 5 feet on this side, 5 feet on the other side, to make 10 feet to 20 feet, like that. And keeping that in provision, you have to keep this setbacks, front setback.
Thank you, Ramte. And next question is: so much complicated procedure, is it possible to make it simplified? Which procedure are you talking about? It depends on that. I don't know. Yeah.
You have already referred to that the minutes of the meeting that was held an year ago. That there was 12 departments from which the NOC was required, but now it has come down to 4, Even for if, say for example, if you construct a building within the air funnel, then only you have to go to the Civil Aviation Authority, like that. So if you construct a building outside the air funnel, you don't have to go to Civil Aviation Authority. So in that way, many department has been skipped, and like that. Only the land use clearance from RAJUK is necessary. For example, if you don't construct a building within a certain area of the key point installations, then you don't have to obtain permission. If you don't construct a building within the heritage, within certain distance of the heritage, you don't have to obtain permission like that. So now it has been reduced to 4 from 12. So in that way, it has been reduced. And if you mention about the complicacy of how the application is made in form 301, 302, like that, there are that is very still to be decided by Raju, how it can be shortened.
Thank you. Thank you, Bhai. And the next question is the Environment Act 2010 should be enacted in BNBC 2020 in amended to ensure ETP plant in industry. This is a very good point. The Environment Act 2010 is already enacted, but BNBC should be consistent with the provisions of the Environment Act. This is you are absolutely right. I hope in the next version of BNBC this will be seriously considered. Thank you for the suggestion. What chapter or clause of Building Construction Act Vidhimala is mandatory for design engineer? What chapter or clause? Actually, to my understanding, all the chapters and all the clauses, as long as they are applicable, are actually mandatory for design engineers, as long as those are related to the responsibility of the design engineers. So you have to check that what clauses are actually related to design engineer. I cannot name the clauses right away at this point, but those which are related to design engineer are all mandatory. They're not optional. How to see the previous lectures? Dr. Prabhuto, this is a question probably for you. How to see the previous lectures?
Well, we are recording all these sessions, although we have not really decided what to do with these recordings. Maybe we will share it, upload them on YouTube or something at some point. We'll need to decide on that. So, but once we decide, we'll let you know one way or another. Thanks.
So, Mr. Masoom, hopefully you will have access to those lectures in future. Then Vidhimala has the priority over the BNBC. There's nothing mentioned about the BC committee in BNBC, but it exists in the Vidhimala. Does the BC committee still effective after the publication of BNBC 2020? This is a very interesting question. This is tricky. Yes, you are right. Now, there's no mention of BC committee in the BNBC, but BNBC talks about building officials. And in the definition, it is written that building officials are equivalent to authorized officers. And in the Act, it is said that whatever the responsibilities of an authorized officer are, that may be conferred to a BC committee if the government desires to gazette notification. So in that way, ultimately BC committee is responsible through BC Act. So BNBC talks about building officials, or in other words, authorized officer, and BC Act is saying that roles and duties of the authorized officers can be performed by the committee. So that's why the BC committees are relevant. Which BNBC code will be applicable if construction is initial stage now? BNBC 2006 or 2020? It is related to building permit. Once you have the building permit, the during your application of the building permit, the code of the code applicable at that time, you have to follow that. So once you get the building permit, you don't need to switch to BNBC 2020, since in the building permit it is mentioned of about BNBC 2006. So it depends on the time when you get the building permit. Sir, at just a highway, how many story permitted to construction? Any highway height limitation? I don't know. Alam bhai, can you help me?
Yeah, there is a highway. There is of course, restriction. If you step into the jurisdiction of the highway, there is a right of way. You know, right of way is the width of the acquisition for highway. So if you are constructing building outside the right of way, then there is no restriction. You can go ahead. That is what it is saying. But you cannot encroach. You cannot encroach within the right of way of the highway.
Okay. So the next question is permitting and regularity and regularity, government body, regulatory probably, government body also should be liable like professional also to ensure justice and welfare. Yes, yes. But an aggrieved person, a normal person against which the regulation has been imposed, he or she cannot go to the court. So the regulatory body is indemnified by the act. But if the government wants, the government can take actions against the regulatory body. So that is the purview of the government. But a normal citizen cannot sue the regulatory body. It is indemnified by the act.
Yes, once you have to prove that you are working on good faith.
Yes.
Once you can prove that you have worked in good faith, then you are definitely indemnified. And the present situation is that the RAJUK is not precisely working as a regulatory body. It is working a kind of mixed character. For example, it is also regulating the BNBC, and also it is working as developer kind of. It's a huge development activities going in RAJUK. There are a number of housing sectors, I mean, projects. So in that way, I mean, when the mixed character is prevailing, then the government can definitely, I mean, catch hold of RAJUK for violation of any rules and regulations. But once RAJUK is transferred, as we are proposing now, RAJUK should henceforth work as a regulatory body, as has been mentioned in BNBC. Then RAJUK will be totally indemnified, and the professionals will take the responsibility of building design. If anything goes wrong in the building design, the professionals will be responsible, not RAJUK.
Thank you. This is very important.
A very important and very tricky kind of thing. There's a third-party system which we are recommending.
Yes, you can sue the activities related to the development activities of RAJUK, because those are not regulatory activity. But those actions of RAJUK which are under the BC Act, those actions you cannot sue. But
for example,
actions which are TI Act, you can sue for against those actions if those are not in according to the Act.
Exactly.
So I'll take only one more question because we have run out of time. Somewhere in your presentation, you mentioned that Vidhimala will prevail the code if there are any ambiguity. My question is not it contradictory as code come before the Vidhimala? Yes, yes, you are right. But in the code, it is not mentioned that the code provisions will prevail over Vidhimala. But in Vidhimala, there is no mention of date or anything. It is just mentioned that it will prevail over code whenever the code is published. So from that point of view, Vidhimala will still prevail. Alam Bhai, am I right or wrong?
I mean, yeah, this was debated also before that whichever prevails what. But according to my opinion, I always hold this opinion that code prevails on top of Vidhimala.
So we need legal opinion advocacy.
Yeah, it's a legal interpretation. And, yeah.
Okay, so the other questions, we'll keep record of those questions and we'll get back to you soon, probably. So, and I thank you again for your patience and your participation. That's so much encouraging for us. Thank you so much. I conclude here for tonight. Thank you.